So we got involved in the case about 5 years ago. Mr. Long has a wife who's his strongest advocate, Ashley, and Ashley had contacted the clinic and said that numerous people she had spoken with had said that there was no further chance that Long's case would ever be heard in court again. We reviewed the facts of the case and were deeply concerned and troubled by those facts, because upon our review, it was revealed that what was presented in the state courts was evidence that had been suppressed or withheld from Long for 3 decades before people got involved in helping him, or the prior attorneys were involved in helping him. And not only was material suppressed for all this time, but during the course of the proceedings at Long's trial, officers testified falsely regarding the material they collected and the testing or the forensic tests that were performed on that evidence. That was very troubling to us, that in light of very clear suppression of evidence and false testimony, Long's conviction was upheld by the state court system. We got involved and said we'd see if there was a possibility of bringing a habeas case on behalf of Long in the federal court. That case was filed by the clinic. It has bounced up and down between the Fourth Circuit Court of Appeals. And ultimately, we recently in January had a 2-1 panel decision that ruled against Mr. Long and effectively granted, on remand, would have resulted in a grant of summary judgment for the state of North Carolina. After receiving that panel decision, with the help of Shoshana and Nicole, we drafted a petition asking the full Fourth Circuit to rehear the case, and last Monday heard that the full Fourth Circuit was in fact going to hear the case. The evidence that was presented at trial against Long was an eyewitness identification that occurred 14 days after the crime had occurred. Mr. Long in May will have served 44 years in prison. There were all sorts of problems with the eyewitness identification, problems that we know caused them to be unreliable, including the fact that Mr. Long himself does not correspond with the pre-identification that the witness had given. So there were facts in the description that the witness had given after, or victim had given after her attack, and the information that she had given in the description doesn't match Long, which is problematic. When she identified Long, it was during the course of this really unheard of procedure where she was taken in a disguise in a courtroom. The officers told her that the person that they believed had attacked her would be present in that courtroom. She was asked to sit in the courtroom and try to see if she could identify her attacker. She sat there for an hour and a half in the presence of Long. He was there the entire time without identifying him. She subsequently identified him only after his name was called, and he had walked up. He was appearing on a trespass charge because he was in the park that was adjacent to his home when he wasn't supposed to be there. So that's why he was appearing in court that day. It was just a simple trespass charge that was actually dismissed that day. She identified him after his name was called and after being there for an hour and a half. She would later testify that during the entirety of that period, she was terrified because she was fearful that she was in the presence of her attacker, and that when she selected Long, he was the only one in the courtroom that looked remotely similar to the individual who attacked her, which explains the differences between her pre-identification description and Long, because the likelihood is that he was only selected because she was exercising relative judgment and just picked the individual who looked closest like her attacker in the courtroom. And that's all the evidence that was presented against Long. The state collected forensic evidence both from the crime scene and from Long's person, sent that evidence to a lab. It was all compared with the instructions of use that material to try and see if you can identify Long as the attacker, Of that evidence, 3 reports were written. They were provided to the Concord Police Department, all indicating that there was no connection between the evidence collected and Long. That was suppressed from Long prior to and at his trial, and officers testified affirmatively that they didn't bring the evidence to any forensic lab so as to hide the fact that the evidence was collected and tested to begin with. So that is the brief sketch, and now we're hoping that the Fourth Circuit in full will hear the case and agree with us that there was a material violation